The next matter to come before the court this morning is Kevin Eslinger versus Pamela McKnight. It's my understanding that the appellant has waived oral argument in this matter, and you have 15 minutes to argue the case this morning.
Thank you very much. This is an unpleasant case because it involves little children whose parents never seem to be able to get it together. They started out very well when the parentage action was filed by Mr. Eslinger. The mother entered into a shared parenting plan with him. Parentage wasn't even established for several months, but she knew this was their father and tried to work with him. In 2010, she asked for a modification, and this was done by agreement as well. 2012, there was another modification, this time so that mother would have the school weeks and dad would have the weekends. And it explicitly states that both were to oversee academics. In 2013, because the father did not return the children, mother filed for contempt and reallocation. And a guardian ad litem was appointed. During her investigation, she recommended to the court that the matter be certified to juvenile court, which declined. So when it came back, it proceeded to trial. The magistrate terminated the shared parenting plan and named mother as residential parent. Father's assignments of error are not supported by the record. The first is that he feels the trial court held him responsible for the academics, and he was not supposed to be held liable, but it's clear in the record that the order says both are responsible for academics. The guardian ad litem and the school records both reflected that the children's academics were not assisted in their academics by father. They missed a lot of school and were late the day after father's visits. The second assignment is the trial court's failure to properly certify the matter to juvenile court. There is no argument, much less any basis for finding that that was error, much less prejudicial. The same guardian would have been appointed. There's no reason to believe the evidence would have been different. Excuse me. He assigns as error the judge's failure to use the dates he suggested in his order for an extension of time for his briefs. The court considered his brief. He showed no prejudice in that regard as well. He alleges that the court acted in a biased manner towards him. In fact, the transcript of proceedings shows that the magistrate was deferential to him and attempted him in trying to raise his issues when he was doing this pro se. He needed the help. The magistrate gave some help. There's no indication of bias. There's certainly no indication of an ultimate failure in the magistrate's decision and the trial court's affirmation of that decision. Finally, in his assignment of error number 5, he expresses concern in the assignment about mother's history of domestic violence convictions. However, he does not point those out either to the trial court or to this court. The record is replete with evidence that would support the magistrate's clear findings and the trial court's adoption of those findings and re-recitation of them in its determination that the objection should be overruled. For this reason, we would ask that the court affirm the decision of the trial court. Thank you.
Thank you, counsel. We appreciate your presentation this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, posted on the Ohio Supreme Court website, which will be linked to.
Thank you very much.